Hello everyone, welcome to V2B Academy and I welcome you all to the class number 2 of Indian Polity Current Affairs for the month of May 2025. So we have completed 6 articles in the last class. Okay, so where I have comprehensively discussed all the 6 articles for the prelims point of view, mains point of view and also for the personality test stage also. Okay, so now let's continue with the topic number 7, right? Justice B.R. Gawai takes charge as the 52nd CGI. So this is the topic. So basically we know in the month of May, Justice B.R. Gawai has taken and has been sworn in the as the 52nd Chief Justice of India. So that's why it was in the news. So in this context, let's see what is the Chief Justice of India. We have to learn about like the details about the Chief Justice of India. So CJI is the head of the Supreme Court. And CJI, he or she will be the highest ranking judicial officer in the country. This is something which we all know. Okay, so CJI is the master of the roster. So basically, CJI will actually have an authority to constitute the benches in the Supreme Court. So there are different benches, the single judge bench, the double bench. So in this way, we will have different benches in the Supreme Court and even in the High Court if you have heard in the news or somewhere. Okay, so these are the benches that are constituted by the Chief Justice of India only, and Chief Justice of India will have a authority to allocate cases among the judges also, like which judge need to take which particular judgment. Okay, which particular judge will who need to handle which particular case. So this is something which Chief Justice of India will decide. So he or she will decide the schedule of the hearings also. So CJI leads the judicial and the administrative functions of the Supreme Court. So CJI will have a administrative control. Okay, he or she will hold administrative control as recognized in the state of Rajasthan versus Prakash Chand case of 1997. So CJI is referred as a first among equals. If you have read some important books like Lakshmikant or somewhere, so you might have seen CJI will be called as a first among equals among the Supreme Court judges. Okay, among all the Supreme Court judges, the more authority will lie under the shoulder of the CJI. Right. So if you look at the appointment and the terms of appointment, so more of it you need to revise it from the Indian Polity Standard book. However, few points I'll try to remind you. So Article 124 of the Constitution will empower the President of India. So according to Article 124, President of India will have an authority to appoint the Chief Justice of India. Traditionally, what will happen is the President will choose a senior most judge of the Supreme Court to make him be appointed as a Chief Justice of India. But there are few exceptions in the past. For example, in 1973, Justice A.N. Ray was appointed over 3 senior judges. So despite 3 senior judges above him, so A.N. Ray was chosen during the Indira Gandhi government. Okay, and next in 1977 also, Justice M.H. Beg was appointed over H.R. Khanna. So these were the 2 exceptional situations in the past, except that all of the cases will choose the senior most judge as a CJI of the Supreme Court. So what are the qualifications that are outlined under Article 324 Clause 3 of the Constitution? So basically, Chief Justice of India should be a citizen of India and he or she must have at least 5 years of experience as a High Court judge or practiced at least 10 years as a High Court advocate. Okay, so 10 years as High Court advocate, or the third condition is deemed as a distinguished jurist by the President. So out of these 3, any one condition needed to be satisfied and he or she must be a citizen of India. So this is the compulsory condition, that is citizenship. Out of other 3, 1 must be there. Okay. So what is the selection procedure then? So basically the selection is actually governed by memorandum of procedure, okay, for the appointment of Supreme Court judges, and Union Law Minister will seek the outgoing CJI recommendation. So basically the recommendation is processed as follows. So basically what will happen is, the recommendation for the selection of the CJI will be sent to Prime Minister by the Law Ministry. Okay. Law Ministry will recommend the Prime Minister. So Prime Minister will then advise the President about whom to choose. Okay. So the President of India will choose the CJI. So basically in this particular process it will happen. Basically Law Minister will send, okay, basically law minister will be sent to the prime minister. So to appoint the Chief Justice of India, then Prime Minister will advise the President, so then President will go and appoint the Chief Justice of India. So basically this is the procedure through which the appointment happens, and there is no specific timeline that is defined in the Constitution. So the recommendation must be made according to appropriate time. Okay, specific time period is not mentioned, but it has mentioned as appropriate time. Okay, so what is the tenure and removal of the Chief Justice of India then? So basically, until the age of 65 years, Chief Justice of India will serve. Okay, and according to Article 124, Clause 4 of the Constitution, so the Chief Justice of India require approval by both the houses of the Parliament. And he or she must be supported by majority of total membership and 2/3 majority of the members present and voting. So basically this is the removal procedure. Okay, so appointment procedure is something which I have already told you. Article 124 clause 4 will speak about the removal procedure of the removal of the Chief Justice of India. So basically the removal motion must be supported by 2/3 majority of members who are present and voting in the both houses of the Parliament. And the grounds of removal will be misbehavior and incapacity, and these both terms are not defined in the Constitution. This is something which you have to remember. Okay. So now let me introduce you to another framework, another main answer writing framework, that is powers and functions framework. So basically whenever you're reading or whenever you're trying to memorize the things which are related to the powers and functions of any constitutional post, what you have to remember is you have to think of in this ways. So what are the different dimensions in which you have to think of the point? One is legislative function, another one is judicial function, third one is executive or administrative functions, advisory functions, discretionary functions, disciplinary or regulatory functions, and some optional additions like financial functions, quasi-judicial. Okay, under judicial only you can add quasi-judicial and ceremonial functions or symbolic functions. So these are the different dimensions you have to think of while writing or brainstorming the points which are related to the powers and functions of any constitutional post. Okay, for example, discuss the role of Vice President of India as the chairman of the Rajya Sabha. So whenever you are writing the Vice President role as the chairman of the Rajya Sabha, you need to write in these particular dimensions only. You have to mention about the legislative functions, disciplinary function, discretionary functions, ceremonial functions, quasi-judicial functions. You don't need to write each and everything, but whatever fits well to this particular post, that is something which you have to choose and you have to write the points. Okay, if you look at the powers and functions of Chief Justice of India, like coming back to the article on the Chief Justice of India, if you apply the same technique over here, that is powers and functions approach. So let's apply it and let's see the judicial functions of this particular post. So basically as he or she is the judge of the Supreme Court, he will be assigned judges to the constitutional benches. So this is something which I have already told you. He or she, the CJI, will have an authority to constitute the benches in the Supreme Court. This is the first function under Article 145, and handles interpretation of some important legal and the constitutional matters under Article 145, and will have a power to exercise judicial leadership also. So if there is any jury prudential direction, so that is to be given. So definitely that will be headed by a Chief Justice of India only. And also Chief Justice of India will have a judicial authority in matters which are related to the national significance. Okay, basically if any matter which is related to national significance is to be dealt, that will be dealt by the Chief Justice of India only. And he or she will have a right to protect the fundamental rights. Okay, so this comes under the original and also appellate jurisdiction of the Supreme Court under the Article 32. Okay. So these are the different powers and functions, judicial functions of the Chief Justice of India. And Chief Justice of India will possess few administrative functions also. He or she will have a power to maintain the court's roster, and the case listing will be done by him only. Okay, so he or she will supervise the court staff, and administration of the court will be run by the Chief Justice of India only. And Chief Justice of India will ensure smooth functioning of the Supreme Court, and he or she will hold a disciplinary authority over the subordinate judicial officers. It means administrative powers are vested in that particular seat. And the CJI will engage in administration of justice at the highest level. So these are the different administrative functions that are therein. And advisory functions, if you look at the advisory functions of the Chief Justice of India under Article 143. So this is also, it is in the news. So President will have a power to consult the Chief Justice of India and other judges to ask for if there is any question of law or if it is of the public importance, that particular doubt can be asked to the CJI. Okay. So that were the different functions of the Chief Justice of India. So now you can test your take if you have bought the PDF from us. Okay, if you have purchased the PDF from us. Next article. So again, Article 143 of the Constitution. This is directly in the news. So let's discuss about it. So why is it in the news? Because the Tamil Nadu CM has criticized the presidential reference under Article 143 as a desperatory attempt to weaken state powers. Following a Supreme Court ruling, the set timelines for governors and the president to act on state bills. So what happened is, what is the background of this particular issue is, in Tamil Nadu, the governor of Tamil Nadu has withhold almost 10 plus bills without giving an assent. Okay, and sometimes governor is giving reference of that particular law like bills to the president for the consideration of the president. So basically what will happen, there are two houses, right? So in the case of states, few states will have one house and few states will have two houses. Let's consider a state which has two houses. So what will happen, the assembly will pass a bill, it will go to the second house, or it will be passed in the second house and it will go to the first house. After the procedure that happens in the two houses, then it will go to the governor for the final assent, right? Governor will have few powers over it under Article 200 and Article 201. So basically under Article 200, governor will give assent to that particular bills. Okay, then that particular bill will become an act. Okay, and under few articles, the governor will have a power to withhold the bill also. That is nothing but a pocket veto. And the governor will have a power to send it for the consideration of the president. Okay, this is under Article 201. So the bills can be reserved for the presidential assent. Okay, once they go to the presidential assent, the president must give an assent to make it, to turn it into an act. Okay. So most of the times these particular provisions are misused by the governor. So most of the times the assent to the bills are not given. Okay. So often governor is using pocket veto, or sometimes they are sending it for the reconsideration, and once it is sent, the governor will be obligated to sign it, but it is not resent. What is happening is the governor is withholding the bills without giving assent, or sometimes the governor is referring the particular bills for the consideration of the president. So these are the provisions that are misused often. Not only in the case of Tamil Nadu, in most of the cases, the governors are misusing these particular provisions. And in the few cases, it might be the genuine cases, but in few cases, they are trying to misuse these particular discretionary powers that are given to them. Okay. So what happened is, so as this particular case is happening, Tamil Nadu CM has approached the Supreme Court, and Supreme Court has told that withholding the bills for the longer duration of time is not constitutional. So Supreme Court has told that the bills must be signed in a stipulated time frame. Okay, a set timeline should be provided for giving the assent to any bill. So this is the judgment that is given by Supreme Court. And what happened is, President under Article 143 has asked a doubt. Okay, so basically Article 143 speaks about an advisory jurisdiction. So where President will have a power to question the or ask any doubt to the Supreme Court regarding any legality of the issue. Okay, so basically the Supreme Court, like the President in this case, has asked the Supreme Court by a few details, like a lot of questions were asked, and the President also asked whether the the set timelines that is mentioned as per the Supreme Court judgment is right or not. Okay, is it constitutional or not? So this is something which was asked under Article 143. I'll repeat it again. So under Article 143, the President will have a power to ask the Supreme Court judges and Chief Justice of India on any matters which is of public importance. Okay. So it can ask the President can ask the advice, okay, or President can ask any constitutional doubt to the Chief Justice of India and also the other judges in the Supreme Court. So basically in this case, mainly the focus is on this particular aspect, that is setting the timelines for governor assent. So as it is not mentioned in the Constitution of India, so the President want to ask Okay, like president want to clarify a doubt by asking Supreme Court that whether is it legal or not. Okay, setting timelines which is not mentioned in the constitution, if it is interpreted by the Supreme Court in this way, okay, if it is interpreting the executive timelines or executive powers, is it constitutionally valid or not? Is it not a separation of powers, violation of separation of powers? So this is the doubt that is asked by the president under article 143. So this is the context of the news. Okay, so the presidential reference, so basically article 143 is nothing but a presidential reference, asked whether the Supreme Court could impose timelines on governors under article 200 or article 201. Okay, so what is article 143 of the constitution? So article 143 of the constitution empowers the president of India to seek the advisory opinion of the Supreme Court. So basically president will have a power to ask any advice for the Supreme Court on related to any question of law that is related to public importance, are likely to arise or has already arisen. Okay, so if it is related to public importance, definitely president can ask a doubt or an advice to the Supreme Court. Okay, the provisions defines the Supreme Court advisory jurisdiction. So this will be under article 143, and 143 is divided into two clauses, article 143 clause 1 and article 143 clause 2. So clause 1 speaks about the president may refer any matter to the Supreme Court for its opinion. In the first case, the Supreme Court may tender or may refuse to tender its opinion to the president. So this particular provision says that Supreme Court is not obligated to give the opinion. Okay, if president is asking an advisory opinion to the Supreme Court is not obligated to give the decision in the first instance. Okay, under article 143 clause 2, what this particular clause 2 says is, allows the president to refer disputes arising from the pre-constitutional agreements, including state-related matters, for the Supreme Court opinion. So basically under article 143 clause 2, president will have a power to ask any advice to the Supreme Court if the matter is related to the pre-constitutional agreement or if it is related to state-related matters. So Supreme Court must tender in this case. So basically under this article 143 clause 2, Supreme Court must give an opinion. Okay, if it is related to pre-constitutional matter, that means a matter or an agreement which was signed before the constitution, if it is related to it, or if it is related to like state-related matters also, definitely Supreme Court must tender its opinion in the second case, whereas in the first case it is not obligated to give the decision. Okay, so what is the nature of this reference? Supreme Court's opinion is just advisory, and whatever the opinion the Supreme Court gives, it is not binding on the president. Okay, remember, the advice that Supreme Court gives is not binding on the president. It's not a judicial pronouncement, it's just an advice that is given by the court. Okay, so what is the president response? So it is not binding on the president. He or she may follow or may not follow the opinion. However, it will facilitate the government to have an authoritative legal opinion. So it is like asking for a legal opinion only. Okay, so what are the types of questions referred under article 143 then in this particular case? So this allows the president to refer the questions of law or fact. So legal questions were asked, like constitutional interpretation in the case of timelines, or some rights were asked, some powers related to executive powers that were asked, factual questions like Ram Janmabhoomi Masjid reference. So these kind of questions were asked. So this is a case. Article 143 is this particular case where it is an evolving concept. Okay, so month by month you'll be reading the few other provisions that happened in the news. Okay, so this is not a final time that we'll be reading article 143, because throughout the year we may see article 143 in the news for n number of times. So it's like a current affairs that is in like it is building. Okay, it's a building current affairs. So you will see this particular current affairs almost every month till your mains exam or till your prelims exam. Okay, so don't worry, we'll be studying the same topic for more number of times throughout the year. Okay, so what is the judicial interpretation? Supreme Court has clarified that article 143 is broad in scope and it is not limited to questions that have arisen, potential or likely questions that can be referred to. So basically, so judicial interpretation under article 143 or 143, under 143, whatever the advisory jurisdiction that the Supreme Court possesses is very, very huge, and it has a large scope. This is something which Supreme Court has told. Okay, so although 143 vests the powers in the president, the real decision to refer it will be under the Council of Ministers. So basically, president will ask the doubt only when Council of Ministers will advise the president to do so. So this will be derived from Article 74 Clause 1 of the Constitution. And under Article 74 Clause 2, it bars the court from inquiring on such advices that were given. Okay, it is not obligation. Okay, it's not an obligation. It's just an advice. Okay, it's not a legal obligation. So President may follow the advice, President may not follow the advice. Okay, remember this point. Under 145, such references must be heard by a bench of at least 5 benches. So basically, a bench needed to be constituted which consists of at least 5 judges in order to take up this particular cases related to advisory jurisdiction under Article 143 of the Constitution. Okay, so basically this particular references are made based on the Cabinet's advice and based on the Prime Minister and Council of Ministers advice. Okay, so what are the different questions that of the clarity that were asked? So basically, they were asking about Article 143 of the Constitution empowers the President to seek the advice from the Supreme Court on questions of law. This is something which you have already seen. Okay, we have completed discussing about Article 143. So in this Article 143, in the recent case, almost 14 questions were asked. So can Supreme Court impose timelines and dictate the manner in which governor has to perform or governor has to go? Under Article 202.1. Okay, can deemed consent to bills be given through a judicial order? When are constitutional options before a governor when a bill is sent for assent? So these kind of different questions that were posed, almost 14 questions were asked as part of Article 143. So if you look at the historical context, the advisory jurisdiction of Indian Supreme Court under Article 143 has been originated from Government of India Act 1935. Remember this point. Okay, advisory jurisdiction for Supreme Court was driven from Government of India Act 1935, which gave the power to Governor General to refer important legal questions to the Federal Court for the opinion. Okay, remember, this was derived from the Government of India Act 1935. Important for the prelims point of view. So what are the past instances when we have seen the presidential reference Article 143 usage in the past? Delhi Laws Act case in 1951. So this clarified the scope of delegated legislation by the legislator to the executive. So basically the question on delegated legislation was solved here. Okay. Kerala Education Bill in 1958, Berubari Union case, Special Courts Bill, Third Judges case. So these are all the advisory opinion judgments only. You can read it from the PDF or pause the video and just read it. Okay. Have a quick read of it. Okay. I hope you have paused the video and you have read it. Let's continue. So what is the significance of Article 143 and its colonial legacy? Definitely, it helps in providing advisory role to the executive. So this will allow the president to seek the Supreme Court opinion on dealing with complex legal issues or complex constitutional issues. Okay. So which will aid the executive to take any decisions or in order to clarify any questions of law. Okay. For example, the Delhi Laws Act in 1951. Okay, they have clarified the issues related to delegated legislation. This will help in ensuring the constitutional clarity of the cases. So, judges are well versed with the constitution. Their duty is to interpret the constitution itself. So, as the executive and the legislative personnel or legislative people are layman, judges can help them in interpreting and ensuring the constitutional clarity. So this help in resolving the ambiguities or uncertainties in the law. For example, the Berubari Union case of 1960. Okay. Next, maintain separation of powers. So this helps in dealing the judicial issues by the judges only. Okay. This helps in separation of powers amongst the three organs. Okay. So the advisory nature avoids direct judicial interference by the executive. Okay. For example, Supreme Court may decline vague or political questions as in the special courts reference. So when the question advisory jurisdiction was used in 1978 under special courts reference bill, so this was not like the questions that were asked by the president were declined. Okay. Supreme Court did not answer any questions. So this ensures separation of powers. Okay. And what are the key issues that are raised under Article 143 reference recently? So one is the judicial review of executive direction, okay, or executive discretion under Article 200 and Article 201. I have already told you the context. Next one is imposition of timelines. Is it constitutionally valid or not? Okay. Concept of deemed assent. So the reference challenged the Supreme Court introduction of the deemed assent concept, questioning its compatibility with the constitutional framework. So basically, deemed assent. So basically what happens is Supreme Court has told that if in the set time frame, so if governor is not giving the assent, it will be deemed as an assent. Okay, it will be deemed as if the governor has given the assent. So is this, the concept of the deemed assent is constitutionally valid or not? So this is also a question that was raised by the president under article 143. Scope of article 142, this was also asked. Article 142 gives the Supreme Court power to pass orders to do complete justice. So what is the scope of article 142? So this was also questioned under it. And they have questioned about the justiciability of executive actions pre-legislation. So before forming any legislation or any law, so how much authority the judges will have in the executive actions. Okay, so this was also asked. Next one, how this particular move will impact federalism and democratic functioning. So Supreme Court's opinion will influence the center state power dynamics and safeguard democratic processes. For example, the Kaveri dispute advisory opinion and reinforce limits on court's advisory. So basically they were questioning about whatever the judgments that the Supreme Court gives, how will it impact the federalism, how will it impact the democratic functioning. So these are the different questions that were posed under article 143. Okay, so how does the advisory jurisdiction compare globally then? So if you compare it with Canada and USA, so we have bought it from Government of India Act 1935, whereas Canada also has a colonial legacy for the advisory jurisdiction, whereas United States doesn't have advisory jurisdiction. What is the nature of the opinion? Our nature of opinion is not binding. Okay, whatever the advice Supreme Court gives, it's not binding. Okay, it's just a persuasive move. Whereas in the case of Canada, it is also not binding, whereas USA doesn't have the advisory jurisdiction provision itself. Who can refer it? Council of Ministers advise. On the advice of Council of Ministers, President will refer it. Whereas in the case of Canada, federal and provincial governments will refer it. Okay, and in the case of USA, there is no advisory jurisdiction again. Okay. Next one is judicial approach. Supreme Court may decline to give the opinion if it wants so. And basically in Canada, on the request, definitely Supreme Court will give the opinion in the case of Canada, whereas in the case of India, it's not obligated to give. Whereas in the USA, strict separation of powers will be there, so there is no advisory role or advisory jurisdiction that is followed in USA. For example, Article 143 in the case of Berubari Union case. So if you want, you can remember the Canada example also, reference re secession of Quebec. It is not important for the exam point of view, and this is also not important for the examination point of view. Okay, so this is the test your take component. Once you purchase the PDF, you can solve that. Next article, permanent lok adalats. Permanent lok adalats. Why is it in the news? Permanent lok adalat is as many as districts of Rajasthan has ceased functioning owing to the non-extension of tenure of their presiding officers and members. So basically, the permanent lok adalats are not working properly in Rajasthan, in few districts of Rajasthan. So because of the non-extension of the tenure of their presiding officers and because of the non-extension of the tenure of their members, so it is not working properly. So in this context, let's see the permanent lok adalats. Okay, so the context is not important over here. The news is important. Okay, basically permanent lok adalats is important. So what is the legal basis for the permanent lok adalats? So these are the statutory bodies that are established under Section 22B of the Legal Service Authorities Act. So in 1987, we have bought an act called Legal Service Authorities Act. Under it, Section 22B speaks about the legality of this permanent lok adalats. So they were introduced in 2002. So this will help in bringing the speedy and affordable dispute redressal mechanism. Okay, so that we can ensure accessibility of justice for the public. Next one is PLA will resolve issues related to transport, that is air transport, road transport, water transport, postal, telecom, electricity, water supply, sanitation, healthcare and insurance. So these are the different cases that will be solved by permanent lok adalats. So what is the composition of PLA then? So each PLA will have a chairman, so who is a current or retired district judge or higher, and two members. Two members will have an experience in the relevant public utility sectors. And what is the functioning of these permanent lok adalats? So unlike regular lok adalats that are constituted, PLAs will operate in the continuous basis. So the name itself justifies it, right? Permanent lok adalats. So that's why these are working on the continuous basis and they are always available for the dispute resolution. If you look at the jurisdiction limit, they can hear cases involving claims up to 1 crore. Okay, they can hear the issues related to the claims up to 1 crore. But they cannot take up the non-compoundable criminal cases. Remember this. They cannot take non-compoundable criminal cases, and they can deal the claims up to 1 crore only. And unique powers are, if the conciliation fails in the case of permanent lok adalats, so they have an authority to adjudicate the dispute and issue a final binding award also. Just like a civil court, they will have a power to give a award which is binding in nature. So if you look at the difference between the lok adalats and the permanent lok adalats, jurisdiction, the nature of the lok adalats is ad hoc. So these are not permanent, these are very much occasional. Whereas in the case of permanent lok adalats, these are permanent and they function continuously. Okay. And in the if you look at the jurisdiction of lok adalats, the normal lok adalats, these are very broad. They'll take the consideration of the cases related to civil cases, compoundable criminal cases, family related cases. Whereas, so permanent lok adalats will work only in few areas where the cases are up to, the claims are up to 1 crore and limited to public utility service disputes only, like the transport related issues and all. Okay, dispute usage usually post litigation, whereas the permanent lok adalats will deal the pre litigation cases also. Remember this point, very important. Okay, these will deal pre-litigation cases only. What is the panel composition? So basically under the lok adalats, judicial officers, lawyers, social workers will be there. Whereas in the case of permanent lok adalats, chairman who will be a judge and 2 experts in the utility services will be there. Okay, as they will deal with the utility services, the experts from that particular field will be there as part of the permanent lok adalat. So this is the composition of it. Conciliation role. So basically under lok adalats we'll have only conciliation process and no decision if no settlement is there. Whereas in this particular permanent lok adalats, it can adjudicate if no settlement is reached. And the decision is not binding in lok adalats, whereas permanent lok adalats will have a binding decision. In the lok adalats also the binding decisions will be there if parties agrees to do so. Legal status, a decree of civil court. Even in the case of permanent lok adalat, civil court decree will be there, but with some adjudicating power. So the appeal provision, there is no appeal provision here, and there is no appeal provision in the permanent lok adalats also. Okay, this is the test your take component. I hope you have understood till here. Now let's look at the article number 10 of today's news. So the article number 10 or the news number 10 of the Indian Polity May 2025 current affairs, let's see that. Madras High Court judge picks 88% from general category, not from general category. So let's see the context of the news. So during the tenure of Chief Justice D.Y. Chandrachud and Sanjeev Khanna, authorities appointed 15 out of 17 judges to the Madras High Court from the non-OC category, that is from BC categories, OBC categories, MBC, SC and STs. Okay, from the non-OC categories only they have selected 15 out of 17 judges. Remember this point. This is a very great example that you can directly quote in your answers. Okay, by putting this particular thing as context, let's see why BC, OBC, SC, ST representation is very much highest in the Madras High Court. So first one is social justice framework in Tamil Nadu is very, very huge. Okay, Tamil Nadu also have a long history of taking affirmative actions for the sake of the vulnerable sections and vulnerable population, and they have a strict implementation of the reservation policies. So this has helped in uplifting or uprising the BC, OBC and most backward classes, SCs and STs. Okay, so they were empowered to become a part of it. Okay, because of the history of affirmative actions that the state has taken. Okay, better educational access and mobility. So Tamil Nadu is a state which contributes disproportionately to the OBC population, mainly in the higher education. So while Tamil Nadu has about 10% of India's OBC population, it accounts for 13% of the OBCs who are enrolled in the higher education nationally. So therefore we can say that OBCs are huge in number in Tamil Nadu. This is the first thing. And second thing is more number of students, the OBC students are enrolled in the education, the higher education part. This leads to higher qualifications from these particular categories. Okay, so that's the reason they are also having chances to get judicial appointments also. Collegium appointments reflect state demography. Supreme Court Collegium, while selecting the judges from the Madras High Court, they'll make sure that 88% of the appointees are belonging to non-OC categories only. So the collegium also has been playing a greater role. Whenever you are writing collegium related data or anything related to appointments of the Supreme Court, you can mention this example of Tamil Nadu and Madras High Court. Okay, Tamil Nadu or Madras High Court. Okay. And the next question that is to be seen as part of this article is, why do southern high courts have more non-general category judges than if you compare it with the northern part of India? So higher, because this is first reason is because of higher social mobility and because of the educational access in the southern states. So the southern states like Tamil Nadu are having higher upward social mobility, mainly in the BC or OBC or most backward classes groups. So this is reflecting highest enrollment rates in the higher education. For example, Tamil Nadu has 10% of India's OBC population and they are contributing 13% of the OBCs to the higher education. Okay, this is making them having greater access to the judicial appointments also. So next one is regional political and social dynamics. So basically what is happening is, southern states have political environments and social policies that will encourage the non-general categories also to take the key roles. For example, Madras High Court only, it has almost 88% of appointees from the non-OC categories only. Okay. What role that the chief ministers and state intelligence play in these appointments then? So chief ministers of these particular southern states are their opinions are also considered by the Supreme Court Collegium. So that's why the Collegium is also considering taking the people from the non-OC categories also. 88% of them are from the non-OC categories. So their advice is also influencing it. Okay. And also state intelligent inputs are also used while the Collegium is taking the decision. So how does BC social mobility will affect the judicial representation? So women from non-general categories are represented. So one issue is, one important thing, one positive thing is, non-OC category are occupying the important position in the judiciary. That is very good. But most of the times, women representation is often low. So out of 34 women appointed, several belong to BC, OBC, MBC, SC, ST communities, showing some diversity in gender and social groups. But 5 women are only appointed in the Madras High Court, despite of our country having 50% of women population. Women representation is very, very less. That is still has to be addressed in every state, not only in southern part of India. Other high courts also appoint women from non-general categories in the southern states. Andhra Pradesh, Telangana, okay, Rajasthan, Guwahati, Manipur. So these are the states. Most of the states are from northeastern part of India and southern part of India, which are selecting the judges from the non-OC categories or non-general categories. So we have to institutionalize diversity criteria in the appointments, not only in the southern states but also in the northern and the western and eastern states also. And we have to strengthen education and the legal training access, and we have to give equal representation to women also. Till now, we did not see even one women Chief Justice of India. Till now. Okay, if everything seems good, if everything goes well, the first first women CJI of India will be Justice Nagaratna if the provisions goes well. Okay. Now let's go to article number 11, Overseas Citizens of India. So why is it in the news? OCI status of notable British Indian academic has been cancelled due to involvement in anti-Indian activities. So remember this. So remember this context. So in this context, we are reading about Overseas Citizen of India. So when was it launched? This particular OCI was launched in 2005 August. So to give persons of Indian origin a long-term connection to India. So whoever the persons who are of Indian origin, so in order to build a connection with Indian culture, so what we have done is, in August 2005, we have bought a scheme called Overseas Citizen of India. Okay, what is the eligibility for this particular thing? So this is open to those who were citizens of India on August 26, 1950. Or this is also open for who are eligible for Indian citizens on that particular date. Okay, who have a eligibility criteria for being the Indian citizen also, they will also get OCI card. OCI is not like a full citizenship. Okay, this is not like giving the full citizenship. So this is only offering lifelong visa to them, okay, and they'll have some residency benefits. If they are staying in India, they'll have few residency benefits. So they can have a multiple entry lifelong visa. So they are exempt from police registration also. This particular OCI scheme will be administered by Ministry of Home Affairs. If you look at the global numbers, as of 2023, over 45 lakhs OCI holders are there from 129 countries. Top sources includes USA, UK, Australia, Canada. Okay, remember these points. Who are persons of Indian origins? So, persons of Indian origins is a category which was abolished in 2015 and merged with the OCI category only. So, however, existing persons of Indian origin cards are valid till 2023. So, basically, in 2023 only their validity has ended. So, PIOs are also amalgamated into OCI card holders only. So, they are nothing but they are the foreign citizens only, except who are a part of Pakistan, Afghanistan, Bangladesh, China, Iran, Bhutan, Sri Lanka, and Nepal. Basically, they should not be from the neighboring countries, and who are at any time held any Indian passport, or who are either of his parents or grandparents or greater grandparents were born and permanently resided in India and defined as per 1935 Government of India Act. Okay, basically a person can be called as a person of Indian origin when he or she is not from the neighboring countries, but if their parents or grandparents have resided in India as per Government of India Act 1935. Okay, and who is a spouse of a citizen of India can also be treated as person of Indian origin. Okay, so several times it was amended in 2021. Special permission required for visiting restricted areas. So in India also we have few restricted areas which are very sensitive regions. For example, Siliguri corridor or northeastern regions. So in order to enter, if person of Indian origin want to enter these regions, they have to take special permissions also. Okay, so they can only enter for research, journalism or religious work. Other than that, they will not be given permission. So they will be treated as foreign nationals under Foreign Exchange Management Act 2003, and earlier privileges were also there, like in 2005 under this particular OCI card they used to get lifelong visa and no foreign register office registration was needed at that time. In 2007, in parity with the NRIs for adoption domestic airfare, we have brought several changes. In 2009, for having parity with the monument entry and access to regulated professions. So basically in 2009 we have given them few accessibility to few regulated professions in India. So they need to get permission before holding that particular profession in India. There are few ineligibility and limitations also. They are not eligible if individuals with parents or grandparents are from Pakistan or Bangladesh. So if they are foreign military personnel or active or retired ones, so they will also be not included. So if the spouse is foreign spouse eligible if legally married for at least 2 years. Okay, if they are marrying in Indian one, so they have to be married at least 2 years of that. Okay, after 2 years of that only they will be getting this OCI card. Okay, and no political rights. OCI card holders cannot vote, they cannot contest elections also, they will not hold any constitutional post in future, like they should not become president, vice president, Supreme Court judge or High Court judge or anything, or they cannot work in Indian government services also. Okay, this is about OCI. More of the information will be part of your standard book of Indian polity. Once try to revise it. Okay, so one thing that I have told you to revise is CJI appointment, and second one is OCI. Okay, these are the two aspects I want you people to revise. So test your take. Now let's see article number 12. Okay, so article number 12, getting the micro picture at the panchayat level. So why is it in the news? So recently what happened is Panchayat Advancement Index baseline report was introduced in April 2025 for the period of 2022 to 2023. So this has given few data related to Panchayat level or micro picture was given. So this is the context. Now let's see what is given and what are the milestones that we have achieved with respect to Panchayati Raj. Okay. So why does it mark a major milestone then? So basically whatever the data that we collect from the Panchayat Advancement Index, this data will be presented in a most understandable manner. So this data will be given to the Gram Panchayat officers and leaders who are there in the local level. So they'll be using this particular data in order to understand and in order to find the gaps that are there. Okay, so they'll identify the gaps and they'll take the targeted actions. For example, a Sarpanch can use this Panchayat Advancement Index report and scores to improve the health or education outcomes based on the outcomes that the village has performed. Okay, the data that village has received with respect to this index, and it links data to the outcome. So it moves beyond the raw data that is there. So basically these indicators will help in coming up with the development related results. So if that particular Panchayati Raj is not performing well with respect to health, they can come up with the health related intervention. For example, if PAI scores reveal in the Panchayat is truly healthy, guiding specific intentions to improve the well-being concept also. So what is this Panchayat Advancement Index? So this is an index. This uses 435 local indicators, which are 331 out of it are mandatory and 104 are optional. Okay, so these uses 466 data points across 9 themes. So you don't need to remember all these numbers, just remember that most of the indicators are used in it. So based on it, we'll get the performance of the 2.16 lakh gram panchayats. So almost the data of 11,000 plus gram panchayat are excluded for non-validation, yet we have got 2.16 lakh gram panchayats data under this particular thing. Okay, so these are very understandable in nature. Okay, even you and me can understand it in a very easy way. Okay, even the sarpanches and the local leaders can understand it in a very easy way. In that way, in that particular understandable way, that will be presented. Okay, so while 25 states or UTs provided almost complete data, Uttar Pradesh reported 40%, only the 40% gram panchayats, and the rest other gram panchayat data was not presented by Uttar Pradesh. Okay, so outcome oriented data, so this data will reveal or this will help in finding out the gaps that are there, and it based on the data and based on the gaps that we have identified or the local leaders have identified, so based on that they can come up with the targeted interventions. Okay, so what are the main limitations then? One is inaccessible data. So one problem is delayed data and inaccessible data. So basically whenever this particular survey was conducted or when the data is taken from the states, they are not presenting the data timely. Okay, the data is most of the times inaccessible. Okay, so this is leading to delays in the census, and this is really dealing, or this is resulting in not releasing the data, okay, in a timely fashion, as states are reluctant to give data and the data is inaccessible. So most of the times data is not properly used, okay, by the leaders. So they are not taking proper interventions even when the data is presented. And the top down data flow, data is often generated at the grassroots, but it is primarily used by the officials who are there in the state levels or national levels rather than the leaders who are there in the local levels. This is the problem. Okay, gram panchayat data is collected but rarely used by the local elected representatives, but they are being used by the state level authorities or the higher authorities who doesn't have a higher say in this particular thing. So now let's see one particular important thing that will help us writing few answers in the mains exam. So as part of this article, there are few things that are mentioned as part of this particular index. One is gram panchayat representatives, that are sarpanches and ward members, can understand their panchayat performance very easily based on this data. State and district level officials and block development officers and district collectors can use this particular data to plan their developmental plans. And elected legislatures like MPs, MLAs can identify the local gaps, and they can fund through the MP LAD schemes and many more. And line departments and frontline departments can use this data for coming up with the schemes related to health, education and rural development, etc. Civil society organization can bring this or can use this data to bring the awareness and to put pressure on the other stakeholders. And citizens and local communities can use this data to make the leaders accountable for the actions that they have done. So these are the different stakeholders. Okay, these are the different stakeholders that are involved in the proper functioning of the Panchayati Raj institutions. So this is something which I have taken in order to make use of it in the mains exam. How to use this particular thing? So we have identified different stakeholders that are listed in this article, right? So one stakeholder is local self-government, one stakeholder is grassroots democracy, Panchayati Raj institutions. So these are the different stakeholders. Okay, let's see once again. Gram Panchayat representative is the stakeholder number 1. State and district level officials are the stakeholder number 2. Elected legislatures like MPs and MLAs are the stakeholder number 3. Line departments and frontline workers are stakeholder number 4. Civil society organizations are the stakeholder number 5. Citizens and local communities are the stakeholder number 6. So now utilize this in answering any question that was asked on the Panchayati Raj institutions. For example, let's take a previous year question. How can local self-government be strengthened to promote the inclusive development? So to promote the inclusive development, how local governments have to be strengthened? So think of it in a stakeholders approach. So there are different stakeholders that we have identified with respect to Panchayati Raj institutions, right? So what are the steps or things that we have to reform with respect to Gram Panchayat representatives? What are the steps we can take with respect to state or district level officials? What are the steps that we can take with respect to elected legislatures, line departments, civil society organizations, citizens and local communities? Think of in this stakeholders approach in order to generate the points. I hope you have understood how to utilize it. So if tomorrow if there is any question in the mains with respect to Panchayati Raj institution, think of all of the stakeholders and try to identify the loopholes or try to identify whatever the question demands. Okay, I hope you will use it next time when you write the answer. Okay. How all the stakeholders can help in achieving the local sustainable development goals then? So this particular index and these stakeholders will do the targeted planning based on the data they receive, and they'll implement based on the gaps that they have seen or identified. For example, a panchayat noticing low scores in sanitation will prioritize toilet construction and the awareness. Okay, they'll implement proper Swachh Bharat Abhiyan. Okay, they'll come up with a Swachh Bharat Abhiyan drives. Resource optimization and fund collection. So basically fund allocation will be done based on the needs and based on the scores that they have achieved. Okay, so this will help in resource optimization. This will help in bringing effectiveness and efficiency in the funding. Okay, resources. Next one is community mobilization and accountability. So definitely when this particular scores are being out, definitely community will be knowing in which areas they are lacking, and definitely that will encourage them to come out and participate in developing that particular area. For example, an NGO working with local residents can organize meeting to explain their PIA score, and also along with the NGO and along with the civil society organization, they'll help in. So community will actually collaborate to come up with the improvement in the education or health or any particular area which they are underdeveloped. Okay. Where does data submission fall short then? One is most of the times the data is incomplete. So most of the times, for example, we have taken example of Uttar Pradesh, right? Only 40% of the data is given and rest of the 60% is not given. So here we are seeing policy gaps. And most of the times this will lead to the misinformed decisions. And this will lead to inequality. Skewed data will always result in the unequal resource allocation. That is one problem. So what are the steps that we need to take then? We need to come up with a national data sharing and accessibility policy. So this particular policy is under 2012. This was brought in 2012. The government made non-sensitive data publicly available in open accessible formats to promote transparency through this particular program in 2012. And next one is Panchayat Advancement Index that we have just now studied. Okay, this will help in coming up with the developmental based approach and also to come up with the targeted interventions. And also government has been using technology and portals. The government has created few online portals like Panchayat Advancement Index portal for easy access of the report. Okay, for coming up with the targeted interventions and schemes. Okay, constituency wise reports are also been made available online. So what should be the way forward to improve? So first thing is we have to improve the data accessibility and visualization, and we have to strengthen the data validation and the coverage of the area. Okay, so these kind of steps can be taken. I hope you have understood that particular article. Next, elections to the Rajya Sabha. So the Election Commission of India has announced biennial elections for the 8 Rajya Sabha seats, including the 2 seats from Assam and 6 seats from Tamil Nadu. So that's why the Rajya Sabha elections is in the news. So that's why we have to see the static part of it, which is important for the exam. So if you look at the Rajya Sabha elections, Rajya Sabha members are indirectly elected by elected members of state legislative assemblies and union territories electoral college. Okay, so basically what I'll give you a homework. Okay, instead of simply explaining what is there in it, so all of it is derived from your static notes only. Go back to your static book. And try to revise the Rajya Sabha elections today. Okay, before sleeping, make sure you read this particular Rajya Sabha election. I have given the other homeworks also, right? So I have told you to read Overseas Citizen of India. Okay, so now read the Rajya Sabha elections also in detail. Please revise it before sleeping. Okay, make sure you revise it today itself. Don't postpone the things. Don't procrastinate. So this is all derived from the static notes only. It is waste of time if I explain again. The last news article, Supreme Court Collegium recommends transfer of High Court CJIs. The Supreme Court Collegium has recommended the transfer of the 4 Chief Justices from the High Court of Madras, Rajasthan, Tripura and Jharkhand. So that is why it is in the news. Again, they have given about the collegium system. Okay, so the collegium system is again part of the static concept. So this is the 4th homework that I wanted to give you. Please revise the High Court appointment, transfer of judges, Chief Justice of India appointment, all of this from the static book that you are reading from. Okay, all of this again derived from the same thing, the static notes of Indian Polity, that is from Lakshmikant book. Okay, so M. Lakshmikant book covers all of this. First homework is Supreme Court CJI appointment. Second homework is Overseas Citizen of India. Third homework is collegium system and High Court transfers, High Court judge appointments, etc. Okay, try to read it. And fourth important homework that I have given is, so just now I have given, I forgot which homework I have given. Rajya Sabha elections. So this is the 4th homework that I have given you. Okay, Rajya Sabha elections. So let me write it once again. Collegium system and CJI appointment. Okay, with respect to High Court judges transfers, appointments, all of this. I want you to revise all of this in detail. The articles related to it, other detailed provisions that are related to it, OCI. And third one is Rajya Sabha elections, member elections. Okay, member of parliament of Rajya Sabha elections, how it will be done, what are the different criteria, what is the eligibility for being the Rajya Sabha member, all of it needed to be revised. Okay, and one more important analysis that you have to do is, what is the need of Rajya Sabha? Why we have a second house? Okay, why a Rajya Sabha is needed? Is it necessary to have Rajya Sabha? What are the functions of it? How is it differing from Lok Sabha? So if we want to remove Rajya Sabha, is it worthy or not? So this is analysis that I wanted you people to just do a research on it. Okay, try to read it from the Google or anywhere. Try to do an analysis on this particular topic. Okay, 1 mains concept and 3 or 4 prelims concepts from the static part I want you people to revise. Okay, so with this we have completed the discussion part. So in international relations, purely as it is from the current affairs, I have decided to make you understand everything in detail. But in today's PDF, most of it from the static concept. The context of the news is something which you have to know, except that everything is derived from the static concept only. In most of the places if you observe. So that's the reason I have given 3 to 4 homeworks and I have asked you to revise it from your static notes, rather than I explaining once again. Okay, instead of duplicating the work, I wanted you people to read it from the books. And the 1 main concept that I have told you is, what is the relevance of Rajya Sabha today? Okay, so that is something which you have to read. Okay, try to analyze that particular thing. Okay, so before reading it from the Google or anywhere, try to brainstorm it. Yeah, with this we have completed the discussion. So I hope you have enjoyed today's video, but most of the people are watching the video and not giving any feedback. So I want you people to give the feedback, because it takes lot of efforts to make the PDF, collect the information and take the classes, right? So I want you people to give the feedback. Like the video if you like it. If you want to purchase the PDF, mail us or you can DM us in the Instagram, the links of which are in the description box. Okay? So let's meet in the next class. Until then, take care, bye-bye, and make sure you hit the subscribe button, click the notification bell icon and like the video. Okay, let's meet in the next class. Bye-bye and all the best.